You're Marcus Elam? And Mr. Elam was previously in court, pled true to counts 1 through 7 in a motion to revoke unadjudicated.
The case opens with Marcus Elam, who previously pled true to 7 counts on a motion to revoke his probation. His original offense, burglary of a habitation, is a second-degree felony in Texas, meaning it's serious business. The court notes that he was already on probation, but now he's back, facing consequences for further violations. The tone is somber. Everyone acknowledges this isn't his first misstep. Defense counsel opens by admitting that Marcus made mistakes, but argues he's now ready to change. After spending time in custody, Marcus supposedly recognizes the gravity of his actions. His attorney pleads for another chance, stating that Elam wants to return to work, help his family, and prove he's capable of turning his life around. Marcus then speaks, apologizing for his past behavior and vowing to do better. However, courts are not built on apologies.
Received an updated pre-sentence report. Has everyone had an opportunity to review that report?
I do.
Are there any additions or corrections to the report?
No, nothing's been changed.
And it was unagreed. Mr. Lewis, you may proceed.
Judge, this is a situation where it's no doubt that Mr. Elam made several mistakes while he was on his probation, not following up on his obligations. After speaking with him, he's been in custody this length of time here. He is definitely, from what he's telling me, willing and wanting to comply with the court's orders, and feels as though he could successfully complete his probation given that opportunity. He understands that his mistakes, has definitely been costly and put him in this decision. He understands that's totally on top of him, and of course he would like to address the court as well as far as his plans for the future, Judge.
All right, go ahead.
Yes, ma'am. I'm sorry for my action.
Marcus's attorney brings up a key reason for his past failure to report. He was grieving the loss of his grandmother, who had been a major part of his support system. This explanation adds some humanity to his case, showing that emotional trauma may have played a role in his derailment. The lawyer affirms that Marcus still has support from other family members, and that several have even contacted the defense to vouch for him. The implication is clear. With guidance and stability, Marcus could succeed. Yet, it's also a familiar courtroom narrative, personal tragedy, followed by spiraling decisions. Sympathy may be warranted, but the law doesn't bend for feelings. Meanwhile, the judge starts digging into more troubling facts. 5 new offenses have been alleged while Marcus was still on probation. This isn't just about missed meetings anymore. It's about public safety and repeated behavior. For someone who says he wants to improve, the record paints a different picture. The court now has to reconcile Marcus's words of reform with a trail of violations and unfinished programs. Grief explains a lot, but it doesn't excuse everything.
I have to start over, get life, live with my family, go back to work, help my mother die, give her bills, and everything else,
Okay.
And Judge, I'm sorry, I was going to say, Judge, if I may, one of the biggest issues I explained and talked to Mr. Elam about was him not reporting like he was supposed to do over that span of time. And he expressed to me that at that time he was dealing with the death of his grandmother, as far as I think she was a big part of his support system. He does have, I've been in contact, several members of his family have contacted me about him, so he does have a support system that's there. I think she was a big part of it. And after she passed away, I think he kind of went astray at that point, my understanding, Judge.
What is the status of the 5 new offenses that are alleged?
believe they should all be.
What happened, so what was the deadly conduct from August of 2023? What was the outcome of the, or, I guess I'm trying to figure out what happened on all of them.
My understanding, Judge, is he has cases that are pending in misdemeanor court, but nothing here, Judge, that's been accepted as any additional.
I mean, he pled true to the deadly conduct, discharging a firearm, from August 16th of 2023, Can you tell?
The judge presses the prosecution and defense for clarity on the new offenses, especially the most alarming, deadly conduct involving discharging a firearm. The prosecution confirms that Marcus pled true to this charge, meaning he admitted to it under oath. That admission alone elevates this case from a simple probation revocation to a serious public safety issue. Discharging a firearm is not just a mistake, it's a potential tragedy waiting to happen. The judge continues questioning the status of his other pending charges, including evading arrest and failure to identify. Some charges were dismissed, but others remain unresolved. The courtroom mood darkens as the truth becomes unavoidable. Marcus didn't just violate probation by missing meetings. He was actively committing new crimes. Despite his attorney's efforts to emphasize emotional hardship and support systems, these new offenses undermine any credibility of real change. The judge needs more than emotional testimony. She needs hard proof that the defendant is ready for reform. And based on what's emerging, Marcus's track record speaks louder than any apology or promise.
From February of this year, I want to know what the status of everything is.
There was an obstruction in 2023 that was dismissed.
Birthday gentleman. Just said unlikely to prove.
I mean, he pled true to it, so obviously there's that. All right, Ms. Malfino, what's the state's position?
Judge, I'm kind of torn on him. Obviously, the concern is the length of time he absconded. I mean, it wasn't just a month or two. They looked for him for almost 2 years, a year and a half at least. And in that interim time period, regardless of them having been filed or accused or whatnot by the intake division, he has pled true to at least the court standard of having committed all of those new offenses while on probation. Although he has no felony convictions, it looks to me like you ordered him to ISF cognitive in 23. Mr. Lewis had made mention that he never went. I don't know if they didn't have a bed for him and eventually he timed out of that, or something happened and the new offenses came up and they would take him.
I think when he had the prior MTRP, I don't know if it was at the new case or a prior MTRP, I'm not sure, but ISF was ordered, but at some point, I guess after he timed out or something because he was released from the jail.
The state's position is hesitant, but grounded in frustration. Prosecutor Malfino admits she's torn. Marcus isn't a hardened criminal, but he vanished for nearly 2 years while on probation. That's not a slip-up, that's evasion. The state tried to find him repeatedly, and in that time, new offenses popped up like red flags. Despite being ordered to an intermediate sanctions facility, ISF, for cognitive rehabilitation, Marcus never went. The court wonders if that was due to pending charges, lack of facility availability, or simply non-compliance. The defense argues that outside circumstances prevented him from attending, but the reality remains. The program never happened. The timeline becomes critical. Marcus started his probation at 19, and it's now 4 years later with little to show for it. His evasion, new offenses, and failure to complete assigned programs make a pattern one of disregard, not just misfortune. The judge's patience wears thin. While she acknowledges that young people often make mistakes, repeated violations make second chances harder to justify. The court sees a defendant who had resources, support, and opportunities and still chose not to follow through.
Order to complete moral recognition therapy in lieu of, but he never.
So it was the new offenses that were holding him up.
Correct.
You get an opportunity to be on probation for a burglary of a habitation, and I want to really make sure I've got this right. So you get a deferred probation for burglary of a habitation, second-degree felony. You get out, you commit 3 new offenses. 2 deadly conducts, discharging a firearm, and an assault.
Lays out the timeline with exacting detail. Marcus was given deferred probation for burglary, a second-degree felony. Instead of staying clean, he racked up more offenses, discharging a firearm, an assault involving a family member, and evading arrest. The judge tries to make sense of how someone could be given a break, fail to attend assigned programs, and then disappear for nearly 2 years. It's a long stretch to be unaccounted for, especially when more criminal activity is happening in the background. She questions how many wake-up calls are enough. Marcus had for years to prove he could turn things around. Instead, the courtroom sees a trail of missed opportunities and failed intervention.